Welcome back to the Grow Method. My name is Brett Schklar, and you're here to join us for a special series we're calling Go-to-Market Office Hours. And today we're here to talk about something that, to be honest, I don't think of as a part of a go-to-market strategy, and I'm thinking about it wrong because it should be. It is a defensive strategy. It is a offensive strategy, and it is all about trademarks. It's all about the power of the trademarks as a part of your go-to-market plan. But I don't know much at all about trademarks, to be honest. But luckily, do know someone who knows a lot about that stuff. Her name happens to be Pester Schklar. She happens to be my incredibly amazing and accomplished wife. And so I feel very lucky to have her on the show. Tamara, who are you? Say hello, introduce yourself.
Thank you for that wonderful introduction, Brett. First of all, I'm Brett's wife. I am so lucky to have him as my hilarious and brilliant husband. I am also an attorney. I've been working in trademark and intellectual property law specifically for about the last 25 years. I know that's where everyone's like, what? You can't have been practicing 25 years. You look so young. But yeah,
What?
it's
you
true.
You've been practicing for 25 years.
I
You
know,
look so
right?
young.
Yeah, time flies. Anyway, I'm a trademark attorney. I'm a stepmom. I love my dogs. I don't have any human children of my own, but I do have 2 adorable dogs. And yeah, I love helping people protect their brands.
So one of the things I'm really impressed with, and it's a single chart, and I think is awesome, is your success rate of getting things through.
Yes.
And it's like, and it is not just your success rate, but it's a benchmark across averages. And the average, and I don't remember the numbers exactly, but the averages are like down here, kind of in the lower percentages, and you're like up in the 80-something% range of success.
Yeah, I remember showing you that visual, and you were like, you should use this on all your marketing materials. And of course, we don't have a dedicated marketing person. Well, now that you're helping us, it is going to change. But yeah, so the average success rate of someone who applies for a trademark on their own without an attorney, I believe, is around 40%, meaning 40% of the time they will get a trademark registration issued with no issues from the Patent and Trademark Office, no office actions, anything like that. When they're represented by an attorney, that goes up. I think the average for an attorney-led trademark application is closer to 65%. Our firm boasts a success rate of, I want to say 86%.
I think it was 86%.
And I can get you those. I apologize. I don't have those numbers in front of me, but yeah, it's pretty high. We are known for being pretty aggressive with our strategies. I was just talking to a client earlier today where she forwarded an email from prior counsel where that attorney was like, and it was on a design mark, and the other attorney was like, I don't know what your chances are. This is scary territory because this other company has a registration, and since they have this registration, you're never going to be able to get one. Well, design marks are a creature unto themselves, and it's actually usually easier to register a design mark because you're just specifying that particular design. So I did my own quick research, and it turns out there's a lot of people using a similar mark, which is good and bad. But in terms of registration possibilities, it's actually much better because then you have what's called a crowded field situation, which means basically there's so many people using a similar mark that consumers have come to differentiate amongst the different origins of people that provide those goods or services. So anyway, things like that, where like one attorney, either someone who doesn't usually do trademark law or someone who's just very conservative would say like, oh, yeah, you're never going to get a registration on that. Just avoid it. We're like, well, maybe you can. And maybe here's 3 ways you can go about it because, there's usually some creative way that you can get something if someone's really married to a mark.
Yep. I love that. And, it's very cool. Obviously, I hear generics. I don't hear company names, but I hear like the things that you're doing and how much you're going to bat for these companies. So I think it is pretty amazing. And let's talk about your field of ability to work with companies. So, with lawyers and a lot of other things, whether it's family or corporate or this or that, you have to be accepted by the bar in the state in which you practice, and you have to practice within that state. Otherwise, you have to get other counsel involved if it's in different states. This show is really very national and international. About 85% of the people that watch it are in the US. Do you need to find a trademark attorney in your backyard? And we're in Colorado. Do you need to find a trademark attorney in your backyard? Is it state by state dependent?
No, not unless you're doing a state trademark registration, which we don't usually recommend. The U.S. Patent and Trademark Office is a federal agency. So most trademark issues are nationwide, meaning an attorney just needs to be admitted somewhere. I'm actually admitted in 3 states, although I am inactive in one, becoming inactive in the second. So I'm active in Colorado. I decided I don't really ever want to live or work anywhere else. But yeah, we represent clients throughout the world. Actually, we have clients in Eastern Europe. We've got a few clients in South and Central America, and of course, a lot in different places in the United States.
Gotcha.
So
Okay.
yeah, trademarks.
So it doesn't need to be state dependent because it's a federal thing.
It's not state dependent. The only caveat is that if there's a foreign company trying to apply for a trademark, they do need to engage U.S. counsel. So we can represent companies from anywhere, but they can't necessarily file their own trademarks. Like they need me.
Got it. Okay. Yeah. So let's go back up to the 10,000 foot view for a second. And, again, the audience is mostly CEOs, investors, and some chief marketing officers. And I want to sort of build a story here. I want to talk about trademarks. I want to talk about tactics versus strategies. I want to talk about it being a one and done checkmark thing versus it being a ongoing, proactive strategy and all those things. But let's start with the basics. When should a person file a trademark?
So a person should file a trademark yesterday, basically as soon as you have a brand name, a service name, a company name that you want to move forward with. You should do a comprehensive search to make sure that it's available for use and registration. And the use part is actually more important than the registration. I know that might sound funny coming from a trademark attorney, but you can always use a mark and you have common law rights in that mark, meaning even if you don't have a registration, you do have use. But the other side of that is that these other companies that are revealed by a comprehensive search have rights in their marks beginning on the date of first use in whatever geographic area they've been using their marks. So the first step is to do a comprehensive search and make sure that this brand that you want to use is available and not used by someone else.
Right.
And I say do it yesterday because the process takes a long time. The search itself is pretty quick, the application itself, and working with the client to figure out the description of goods and services. That's that whole thing is maybe a week or two, unless they're dragging their feet, which usually they don't. The part that takes the longest is actually getting assigned to an attorney at the getting assigned to an examining attorney at the Patent and Trademark Office. Right now, it's taking over 8.5 months between when you file and when it gets looked at. So wow. It's a really long delay. It is a little bit problematic for companies that are ready to launch a product immediately. And that's why we spend so much time doing these searches, because you really won't know if the mark is registrable or not. I mean, we have a pretty good idea based on our analysis, but sometimes there's issues that we don't anticipate with the U.S. Patent and Trademark Office. Sometimes they'll cite something which we thought was totally irrelevant, and you need to respond to it. So there's really no guarantee. My point is it just takes a while, and the sooner you can get started, the better.
Do it, the better. When you're thinking about something, when you think about it being a part of your company or your strategy, your brand, is the right time to do it. Yep. So let's fast forward. Let's say you've come up with an idea, you've brought in a great attorney, you've filed the trademark. You've, gone through the rigmarole. There might be some back and forth, and ultimately you get the trademark. You get, approved, accepted, whatever it is. How does that get enforced? Does the USPTO monitor stuff and they keep an eye out for you and they tell you, oh, look, somebody's infringing. Do you want us to go after them? Or is it every person for themselves? How does that work?
Wouldn't that be great if you paid the $250 filing fee and the USPTO was somehow now responsible for enforcing your trademarks? Unfortunately, that's not the case. It is up to the individual registrant to monitor and enforce their trademarks. So we have, monitoring services where we get informed anytime someone files an application that's similar to a mark that our client has an application or registration for, and then we can decide whether or not we want to take action. We also have a service that lets us know if the USPTO has cited one of our registrations against a pending application. So in that sense, I guess the USPTO does a little bit of work. So they will automatically reject a mark if it's extremely similar to something that's already in their database. Right. But, the examining attorneys have a lot of discretion. So there's really no guarantee, unless it's like a really, really, really similar mark for very similar goods or services. And, sometimes it depends. There's a lot of discretion that the examining attorneys have. So they will usually enforce it and reject a later application. It's very close in the mark itself and the goods and services. But sometimes they will cite marks where it's a little harder to see the connection or the likelihood of consumer confusion, which is really the test for trademark infringement. Right. Okay. Sometimes their analysis is a little bit harder to understand.
So the moral of the story is don't count on someone else to do the enforcement. The company or trademark company is the one that really needs to monitor and enforce, because you can't just assume that it's being done by somebody else. So then
definitely don't depend on the USPTO to enforce your mark, because they probably won't. And it's always up to the registrant too. I mean, litigation or actions before the Trademark Trial and Appeal Board are certainly one way to enforce it. But usually you can start with something a little less scary. Usually you can just send out a well-written cease and desist letter, and that'll put a stop to the infringement, assuming that they take it seriously and they're also represented by counsel.
So then let's go to this next sort of part where I hinted at it before, and the idea, I think, before I got to know you really well and got to understand your business really well, I always thought of a trademark as a checklist item. Okay, we came up with a brand, we came up with a product name, we came up with a logo. Let's go get the trademark. And once a trademark has been filed and done, then we're good. And I thought about it as like do it and you're done. Why, and I think most people are kind of like me. I don't usually say that. I actually never really say that. But I think a lot of people are like me.
You're really unique, Brett. I don't think anyone's like you.
Why, thank you. This is a paid endorsement. And so, why is it that people think that way is the first part of the question. And the second part of the question is, obviously I understand that's the wrong way to think about it. But I guess really, why is it that people think about it as one and done? And what does that do to people who think that way?
Yeah, I don't know where they're getting that idea from. I don't know if there's some business class that everyone's teaching where they're like, okay, file your articles of incorporation, file for a trademark, then do X, Y, and Z.
Well, I'll tell you exactly what it is. It is that, I've gone through several entrepreneur programs. I went and learned how to sell stuff on Amazon. And it basically said, step 43 in the 3,000 step process is to file for a trademark. And you don't even have to get it accepted. You just have to file. Once you're done with that, you move on to the next stuff. And they never say, go back, not only is it step 42, but it's also step 866 of the 3,000 things to make sure that you're protecting your trademark. So I've seen it. That's what it is. It's just a check mark for people.
Yeah.
Anyway, I apologize
well,
for
Amazon, we should have a whole another conversation about, because, you know, Amazon has their brand registry. But anyway, I know the focus of this is a bigger picture. So yeah, it is important to file a trademark. I don't think it should be a one and done type of thing where you file it and you don't even check the status, or that does happen a lot. Unfortunately, I represent a lot of the clients where either they filed it or they hired, you know, their business lawyer to file it. And actually I have one situation where one of my friends has a law firm. They used to be in downtown Denver. They used to have someone who sort of did some IP stuff. She filed a trademark for one of their clients, and then she left the firm. The firm moved out of downtown. I think they're in Cherry Creek right now. The time for renewal came up. Well, first of all, actually, I don't remember whether it was a renewal or statement of use. I think they had applied as an intent to use, and then when you apply, when you haven't actually been using a trademark, you need to file a statement of use at a certain point in the process. So this is back when the USPTO was sending physical postcards reminding people of deadlines. They sent this postcard to the office on 17th Street. The firm was no longer there. That particular attorney was no longer there. It may or may not have been forwarded to that attorney at her new firm. In any case, no one ever filed the statement of use. The application became abandoned. A couple years later, there was an issue where someone else was using a similar trademark, and actually the second company had gotten a registration because they had an attorney who was keeping track of, you know, the docket deadlines. We came to a resolution, but it was kind of a mess. It took some time and money to get through that. We did ultimately prevail, by the way. And actually, I think the client ended up getting, we did a license agreement and the other company paid them and whatever. It was a whole thing. But anyway, it is something that should be, you know, like assigned to someone. If the client is doing it for themselves, they should have someone keeping abreast of it, you know, keeping track of the deadlines, keep making sure that their email address is updated with the USPTO. By the way, everything is electronic now. They actually charge you more if you want paper copies of anything. You also, I mean, getting registration is great. That's half the battle. You also really should be monitoring it and enforcing it, because when you have a trademark and you don't do anything about competitors or other companies that are using similar marks in your industry, your mark is getting diluted and your trademark is no longer valuable like it once was.
So let's dive into that a little bit, because I want to talk about that, and I want to talk about, like, you know, how to budget for it and other things. But, you know, one of the things is there are people that use trademarks as a competitive and strategic advantage. It's almost like there's hunters and there's farmers. The farmers sit back and wait for someone to infringe on their trademark, and they're just sort of protective strategy or defensive strategy. There's others that I think are more you know, on the attack, and they are using it as a competitive advantage, and they are using it because they want to win every single gosh darn fight. So how, you know, talk about, and I know you can't talk about actual clients and don't want you to, but talk about in general terms, like, how are some of your clients using the trademark system as a competitive advantage, and what's it doing for them?
Yeah, so I can actually talk about that from both perspectives, because I do represent some very aggressive clients where they're using trademarks as a strategy to not necessarily shut down competitors, but to make it more challenging for their competitors to you know, do business in that space. I also am defending a you know, relatively small client against a really large multi-billion-dollar company that has over 1,500 trademark applications and registrations. So the strategy for clients, both large and small, who want to use their trademarks for competitive advantage is basically, let's register these brands, even if we're not necessarily doing business right now. We can apply as intent to use. We may or may not actually go forward with these brands that we think are so clever, but we want to stop everyone else from using them.
Right. Right. It's an intellectual property strategy, right? Whether it's trademarks, sometimes people use it with patents, other types of things. Is there something unique that, so what's the difference between the companies that are using trademarks as a competitive strategic advantage and the companies that aren't? Are there differences in their growth and their attitude?
Yeah, that's a good question. Yeah. I mean, from like looking at my client roster, the ones that are using it in a more aggressive way as a competitive strategy have had more growth. They have had more significant percentage of growth year over year. There's also an article I think I sent you a few weeks ago from a academic journal that did a study on market valuation of companies that have trademark portfolios, that have significant trademark portfolios versus those that do not. And they actually found that the companies that are actively monitoring, enforcing, registering trademarks have a higher valuation.
Interesting. Yeah. I'm not surprised. I think from, my non-legal perspective, what I think is it's less about the trademark specifically. It's more about how you think about competing in the marketplace. If you think about the market and that there's, when you think about the market, you think about that there is a pie and you keep wanting to have a bigger, piece of that pie, a bigger percentage, even if the industry is growing and the pie is getting bigger, you still want your percentage to increase. And so, it's fun to see the CEOs and the companies that are competitive by nature, and they are using the trademark as a strategy. And it's maybe not just trademarks. It's a lot of other things that they, if they're not getting market share, if they're not growing their pie and piece of the pie of the market, they're failing. It's like, if you're not growing, you're shrinking, even if you're flat, because other people are growing. So I think it's an exciting thing to do. I think that having I know a lot of people have tons of domain names and they use that as a portfolio. There's people who have patents as a portfolio. I think trademarks definitely is an area where you can really protect your turf and go after people who are even trying to get close to your turf. And I light up because I think
that's a good way to put it, Brett. That's a really good way to put it. Of course, you're branding.
Well, thank you. So, yeah. Thank you. So then let's dive into, again, let's go into operational tactics. And let's think about, most of the companies that we work with, I think most of the companies that you work with are, there's some solopreneurs and founders, but a lot of them, and they're great. And especially if they are using trademarks early on, it's a fun experience. But a lot of them, and the ones that are really using this aggressively, and honestly, the ones who have a lot of budget to afford a trademark as a strategy versus trademark as a tactic, they're probably in the 5 to 50, maybe 5 to 100 million types of businesses. So in those companies, who should be in charge of the trademark strategies? I mean, usually when I say
a really good question,
it's a CFO because the CFO is in charge of the legal. Sometimes it's the CEO, but not usually. But shouldn't it be like in marketing? And shouldn't it be like who should be in charge of, in a perfect world where you've seen it the most successful, who's leading the trademark portfolio, trademark strategy charge?
So I'll give you a very lawyerly answer. It depends. It really depends in that.
Damn it! I hate lawyers. I hate when lawyers answer stuff.
Yeah, in that sweet spot where it's 5 to 50 million in revenue. Usually, my clients don't have an in-house counsel yet. Some of them do. If there is a lawyer in-house, I'm usually working with the lawyer directly. Otherwise, I'm usually working with the CEO, the president, the founder. Sometimes I work with marketing people. Sometimes I work with a whole team of people. Sometimes they really don't know who should be in charge. And I'm kind of like the intermediary between departments. On the other side with the solopreneurs or emerging entrepreneurs, I'm almost always working with the founder.
Right.
Founders, when they're starting out, when they're growing their business, they usually want to be very involved in those decisions about intellectual property, and they're usually a little more sensitive about the legal spend too. when it gets to be a bigger company, they have usually come to appreciate the value of their brands. I mean, it is an asset that can be amortized over time, right? Something I learned recently in our tax strategy workshop.
Okay, so don't brush past that, because I think that's a really important point, and I know you learned it, and it makes sense.
Yeah, totally.
Let's pause the conversation because, well, actually, let's put a pin in the conversation about the depreciation of assets.
Okay.
Because I think we need to go back to that. But let's round out, who the right person. And the question I want to ask you is, who is your, I guess, maybe not who's your favorite, because, it's people you get along with, but who, and again, the emerging entrepreneurs, it's going to always be the CEO or some outside counsel that they're using that's using you for trademarks. But for the companies that are doing a couple of million, 5 million to 50 million or 100 million, in your perfect scenario, who is it that is leading the trademark charge internally that gets to work with you?
It's usually marketing. In an ideal world, it's always marketing. Sometimes marketing needs to get authorization from the president or, someone else, the CFO. But some marketing people are very aware of trademarks and branding and, alert about whether or not something can even be used by their company. And they come to me pretty early on. Hey, we're thinking about these 5 brands. Can you do a search and rank them? I love doing that. I love doing it at the early stages before someone gets in too deep,
Yep. Nice. Okay. So you really love to work with those emerging entrepreneurs and really get them early on and help them sort of formulate that trademark strategy.
Yeah, because I love educating people about trademarks. Like, I don't want trademarks to be like this scary thing where it's like, oh, you got to deal with the patent and trademark office. Like, I mean, I don't think it's so much a different language. Maybe I've just been doing it too long, but I really think trademarks are cool and it's pretty easy to understand. And I mean, I pride myself on speaking plain English, not like a bunch of legalese. Therefore,
so we're gonna,
ipsa loquitur. I mean,
so I guess we probably need to bring up the fact that we recently visited my buddy in DC, and we actually stayed in Alexandria.
That was so awesome.
And this is okay. So and again. This is my wife, so I get to bring this up, but the intensity of your nerding out, that we were staying at a hotel right around the corner from the USPTO, you lit up like a Christmas tree.
Yeah, I didn't realize we were staying so close there. It was literally like 3 blocks away.
And what was the name of the bar that was in the hotel?
Oh yeah, the bar in our hotel was called Trademark.
Yes. And it was like,
if you ever look at my social media, you'll see tons of pictures of me with, the signage at the bar, the restaurant, whatever, with the trademark sign. There's all those selfies that I took at the patent and trademark office itself. I think those people, I remember like they called security. They're like, there's a woman who wants to take pictures at our front door. And then we went to the trademark, or I think they called it the IP History Museum or something that's within the office. Which was really cool. So that was a highlight. Thanks for reminding me.
So I mean, it's not only your job, but you definitely geek out about it, which is pretty awesome. Okay, so let's go back to that thing we were just talking about. And again, for investors, for CEOs that are thinking about trademarks, I never thought about this until I learned it recently, but a trademark is an asset. And if you're working with a really sharp and innovative tax planner for your company, you can do something with that. So talk about that for a second of what.
So first of all, trademarks are, and other intellectual property assets like a policy and procedure manual, any trade secrets, obviously patents, they are assets of the business that should go on the balance sheet. And they can be amortized, or like the cost spread out, depreciated over time, which is really great to know because, not everyone thinks about that. I mean, I learned a lot at that tax workshop about other things I didn't know you could deduct or sort of spread out. But yeah, it's a great way if you want to, play around with your numbers, make your bottom line smaller so you don't have to pay as much tax, or to make your balance sheet bigger. As far as valuation, it's a little bit tricky, but it's kind of just based on what other people in the industry are doing and how you use the trademarks and, how active they are, I guess, if the products or services are used in commerce yet.
Okay. So we're starting to wrap up. We're about 30 minutes into this, and I didn't realize how much fun I was going to have talking to you about trademarks.
I love to talk about trademarks. I could talk about it all day.
I didn't realize I was going to have fun talking about it. This is normally a topic that doesn't really light me up, but this is really good stuff. So let's dive into the dollar sign world and the cost and things like that. And so, when you look at how to budget for this, how do you budget for it? Is it, the typical lawyer on a per hour basis? Is it per trademark? And then the other part of that, part B and C of that question is, what about not just filing, but also the protection and monitoring, that sort of enforcement, and not really enforcement, but like knowing what's going on and knowing what to go after side of things. So how do people budget for that? For all of that?
Yeah, that's a good question. They should have some money. We can certainly work on an hourly basis. That's not really what we like to. I mean, in some cases, it does make more sense. If you have a dispute, it's almost always hourly because that's completely unpredictable. You could spend 2 hours resolving an issue, or you could spend 200. Yeah. For new applications, though, we love to work on a flat fee basis, and clients love it because then they know what the cost is going to be. We also have monthly packages where it includes basically either one application or one cease and desist letter, or filing with the Trademark Trial Appeal Board per month. So in general, a single trademark application is a couple $1,000s. Our monthly packages range, there's a couple different packages depending on the scope of the work, but basically it ranges from a couple thousand to I think our highest one is like 10,000. We really love to be a partner, though. We're almost like in-house counsel, but not quite. I don't want my clients to worry that every time they call me that the timer starts. And that is kind of how it works if it's just on an hourly basis. So we've started moving more towards these monthly enforcement and monitoring packages where it's just like, you can call us however many times you want. I mean, I might not pick up at the 20th time that you call, but you can call us or email us, whatever. And that's
and I think that's a very customer oriented way. I mean, we talk about packaging, we talk about promotion, we talk about, eating your own dog food. And I think this is where I love the innovation of the firm you've created. And, you are identifying the pain points that people have, which is, is it going to take 1 hour? Is it going to take 200 hours? And you're putting packages together to help businesses have more predictability in how they're running their business. And they should love that. And they do love that. And I think it's fantastic. So,
so in general, I guess you probably want more of a specific number. So in general,
we don't,
okay.
If you want to, you can. I wasn't expecting to be specific.
No, it's okay.
I just love the idea that you're.
I guess I would say call me or email me if anyone wants specifics.
So then that brings us to our final point, because we are running out of time here, and you obviously know your stuff. You are obviously married to a marketing person, so you understand the marketing side of things pretty well. You've got incredible experience, and you're there to help the business of your clients. If somebody wants to talk to you about their trademark strategies, or look at their trademarks, or have you file it for them and do the monitoring and protection and enforcement, what's the best way for people to get a hold of you?
So they can visit our website, which is tmbtq.com, and there's a page where they can either schedule a call or fill out a form, and we'll get back to you. You could always also email me personally. I guess it's okay to give out my email. You have normal listeners, right? No stalkers.
There's that one guy, but other than that.
Anyway, my email is Tamara, TAMARA @tmbtq.com. They can email me individually. I'm happy to help any of your listeners.
Perfect. And if anybody wants to just reach out to me, I will be more than happy to get you in connection and in contact with Tamara.
Yeah, we should put a link in the show notes too. I'm also going to send you that link about the academic article where it was a really interesting article. I mean, I know, I'm sorry, we're almost out of time, but
about the value of the brand based on trademarks.
Because they, I think it was done by a venture capital firm had like funded this study, and it's just so interesting. It's one of those things that a few firms are now on the lookout for, where previously, like, no one really thought about trademarks that much.
Yep. Well, perfect. Well, listen, ladies and gentlemen, now you know how lucky of a guy I am. Tamara Pester Schklar, TMBTQ, which stands for Trademark Boutique. It is a Trademark Law Boutique. Tamara, thank you.
My pleasure. Thanks for having me, Brett. This was really fun.
Thanks for sharing your expertise, and thanks for making the conversation of legal things not suck for marketers and CEOs like ourselves. So again, thank you, Tamara. And again, any questions that come up, put them in the chat, put them in the discussion, send us an email. We are Grow Powerful, and you can reach us at www.growpowerful.io. I am Brett at growpowerful.io. And, be on the lookout for us on LinkedIn. We do a lot of article sharing. We have a podcast called The Grow Method. We have a YouTube channel called The Grow Method. We have a blog called The Grow Method. We have a lot of other things called The Grow Method. So we hope that you find us on The Grow Method, and we hope that you enjoy some of the things that we talk about. And if there's a topic that has to do with go-to-market motions and we haven't covered it yet, send me a note. I want to hear what you want to hear us talk about. And maybe we can continue to bring in, the experts, the people that are in some awesome fields. And unfortunately, or fortunately, I don't have any other wives, so I can't really offer
no current wives.
So we'll have to deal with that. But anyway, thank you all so much for being a part of the show. Tamara, thank you for being so amazing.
Yeah,
and
thanks again.
We'll talk to you all soon.
Okay,
thanks.
Bye for now.